Hello, everybody.
Good morning. Can we open court?
Yes. Good
Morning,
morning,
Your Honor.
Good morning.
Yes, Your Honor. The Superior Court for the Hartford Judicial District is now open and in session. The Honorable Carl J. Schuman presiding. Good morning, Your Honor.
Good morning. This is the matter of Ronald Smith versus State of Connecticut. Mr. Smith, I see you. Can you see and hear me?
Yes, sir.
All right. Good morning, sir.
Good morning, sir.
And appearance for the respondent, State of Connecticut?
Good morning, Your Honor. Attorney Kelly Davis. I'm here for Attorney Mariani, who has COVID and could not be here today.
Oh, I'm sorry to hear that. But
yeah, he was going to try to log on anyways, but he's really sick.
Oh, that's too bad. Good morning, Ms. Davis.
Good morning.
I set up this hearing really more as a conference than as a hearing, just to discuss some of the issues that are out there and that I think also exist, try to get some clarification on a couple issues. So
Sure.
We're not really so much in a argument mode as a conference mode. Mr. Smith, I wanted to start with you. You filed a request to amend third petition for new trial dated August 27th. Do you have that in front of you?
Yes, sir.
Good. So I read it and I was honestly unclear what you're claiming in several respects. In particular, I was unclear whether you're claiming fraudulent concealment or newly discovered forensic science evidence or both. So could you attempt to clarify?
All right. So as to the Third Amendment petition,
Yes.
it clearly states DNA evidence pursuant to General Statute 52-582A. The reason for that is because at the last hearing, Your Honor informed me and Mr. Mariani that 52-582B1 is for forensic scientific new technique. My claim been based on DNA evidence, 52-582A, except that I was quoting B1 as reference to the analysis done on the DNA evidence that was submitted at my trial via the documents that I submitted as my evidence 1 through 13 or 14, I believe. 1 and 2 is forensic documents. Where they at? Let me get them so I can be specific. Do the court have my packet that I sent in with the amendment?
I don't have the complete packet. I have some samples that Mr. Mariani sent me, but I was hoping you could answer my question as to whether you're claiming essentially as an exception to the statute of limitations,
DNA evidence.
Fraudulent concealment or newly discovered forensic science evidence or both.
I'm claiming 52-582A, newly discovered DNA evidence.
So, I mean, that's not a specific exception to the statute of limitations, which we all know is an issue here.
There is no statute of limitations for DNA.
All right, let me see what you're referring to. The petition for new trial based on DNA or or other newly discovered evidence.
Correct.
That
statute encompasses DNA and forensic scientific evidence.
All right. And then it goes on, that was not discoverable or available at the time of the original trial.
Correct.
Okay, so you're focusing on that language on
Part A. Part A and B, mainly Part A.
Yeah, and you claim there was DNA evidence that was not discoverable or available at the time of the original trial.
Correct, because if I can help clarify, there was misleading DNA evidence at my trial that was submitted. The testimony of Dr. Nina Livingston, who clearly stated that the victim DC tested positive for HSV infection. The DNA evidence that I'm referring to is test results, documents stating negative test results of DNA evidence of HSV.
Right. When I read your third proposed petition for new trial,
I think I tried to clearly state that.
well, I didn't feel that
Right.
way. That's one reason why I called this conference. But I read paragraph 12 and thought you're claiming fraudulent concealment.
Well,
yeah, go ahead.
Paragraph 12, let me get it out, sir.
Yeah.
Here it goes. Paragraph 12 states that after Smith's conviction in the state court proceeding giving rise to this petition, the petitioner discovered that the defendant engaged in a deliberate deception of the truth-seeking process. That's one of the claims, but it's not stating fraudulent concealment. It's just stating that they deliberately deceived the truth-seeking process by submitting false and misleading evidence.
I see. So you're not claiming fraudulent concealment as an exception to the statute of limitations.
Well, this part right here is not basically claiming that, because I believe that I would have to plead that, and I think that was addressed in the first petition for a new trial with Judge Noble, and
Right.
They already ruled that I couldn't get that anyway because, number one, I failed to plead it. Number two, I didn't meet the standards, so that's not in there. So,
Okay, you say this paragraph doesn't allege fraudulent concealment, and I gather from your additional remarks that you're not alleging fraudulent concealment as in any paragraph as an exception to the statute of limitations.
well, I don't think I can because I failed to plead it, Your Honor, from
Okay.
the
Right.
from the original petition, because I think you're trying to well, maybe the state, or that we trying to go back to the how do you term it? If I could find it, the term revert back. I believe the term is something like that.
Sure. Yeah, that phrase makes sense.
Right. Now,
Well, whatever the reason, I just want to try to be clear that you're not alleging fraudulent concealment as an exception to the statute of limitations.
well, I'm alleging everything, Your Honor, but mainly.
Well, so are you or are you not alleging fraudulent concealment as an exception to the statute of limitations?
Can I say this, Your Honor?
Yeah.
What I'm claiming is two-part. That 52-582A, not B1A.
Right.
DNA evidence.
Right. I understand that part.
Right. In addition to the deliberate deception of the truth-seeking process. But I don't believe that I can get that at this time because this is the third petition.
Right.
So I don't know.
I understand some of the reasons, but I'm just not clear on your bottom line here. Are you or are you not alleging fraudulent concealment as an exception?
Yes.
You are alleging.
Yes.
You are alleging.
52-582A and that. Correct. Okay.
Okay.
Yes.
So you are alleging fraudulent concealment. Okay.
Yes, I'm alleging two parts, Your Honor.
Right. Fraudulent concealment is one part.
No,
and
52-582A is one part.
Right. What's the other part?
The one you just quoted, fraudulent concealment.
Fraudulent concealment. Okay.
Yes.
All right.
You want to get me into a bind, then that's what it is.
Well, I just want, because you have proposed to amend the complaint and the respondent and I both are unsure exactly what you're trying to do in the amendment. I want to try to clarify it so that the respondent can respond with a summary judgment motion or whatever appropriately, and so that we have define the issues, because right now I'm just unclear what you're saying in the new petition. But
You're
go
unclear.
ahead.
So you're unclear about paragraph 1 and paragraph, I believe 4. That's unclear to you.
Well, let me.
Paragraph 1 and paragraph 4. That's unclear to you of the Third Amendment petition.
Yeah. So 4 is fairly clear, but I was not clear as to whether you were alleging fraudulent concealment in paragraph 12 or not. And you're saying you are alleging fraudulent concealment.
If that's what you want to call it, correct. Correct.
Well, yeah, that's another exception to the statute of limitations.
Correct.
All right. And the
I
second,
didn't know that term could be used for that, but correct, Your Honor.
okay, all right, yeah. Okay, so what I'll eventually get to, and I want to discuss in this conference, is what documents you're relying on, but we'll come back to that. I just want to turn to Ms. Davis and ask whether you now understand the petitioner to be alleging fraudulent concealment and newly discovered DNA evidence as exceptions to the statute of limitations.
I do have that down. I'm going to get that to Attorney Mariani. So yes, Your Honor. I do see that those are his 2 claims.
Right, right.
Okay, thank you.
Okay, and if I allow the petitioner to file the new proposed amended petition, which I'm inclined to do, because I want to clarify the issues, and generally we take a liberal attitude towards amending petitions. Would you be inclined to file a motion for summary judgment based on the statute of limitations?
Yes, Your Honor.
Okay, all right. So now I kind of want to talk a little about the request for admissions and because the respondent and I felt it was a little unclear, and also what documents you are relying on, Mr. Smith, that show newly discovered DNA evidence. So, Mr. Smith, let's talk about that a little.
All right. With the packet that I sent for the amendment to the court, was in one package. I had the amendment with the sealed envelope with the medical documents inserted in said petition that was attached, that was clearly marked trial, hearing, medical documents. So do you have that, sir?
I don't, but I don't normally get all the documents on a discovery request. So the question is, Ms. Davis, whether you have them.
May I just have a moment to look at Attorney Mariana's box? Thank you. I have it in front of me. It might take a second.
Okay. The last hearing, you asked me to send Mr. Mariani the documents I was going to refer to. So I sent it just roughly a couple weeks ago. This will probably be like my 5th time sending in the evidence. They should have like multiple duplicates of the evidence. But the recent one was when the court asked me to send Mariani exactly what I was talking to. And I sent Mariani and the court copies of the evidence that I was relying on.
Mm-hmm.
So, Your Honor, I'm sorry to interrupt you. Did you want to say something first, Your Honor? Okay, so I have something dated August 15th, 2025, which we received on August 20th, I believe. It looks like it says enclosed redacted medical documents of DC pursuant to practice book. It's in the petitioner's handwriting. Then there's a sworn affidavit. It looks like there's an exhibit 1, plaintiff's exhibit 1, which is medical records, plaintiff's exhibit 2. a statement from the police, which is petitioner's exhibit 3. It's roughly like a 20-page document, Your Honor. I think this is what the defendant's referring to. There's notes from a child advocacy center. There's notes from a police hearing. I don't see a ton of medical records, but there's some.
Well, that's the main ones I was relying on because it's a stack. So it was so many. I sent in the ones that was referring to the DNA evidence. Exhibit 1, clearly marked Asylum Hill Family Medicine, 8/27/2003, lab report for wound culture provided by Fonda Gravino medical doctor, which states that they took a specimen of DC's wound where they testified that he had an open sore, which they tested positive for HSV. They took this wound culture and did a lab report on it, which gave a result of, if you could read it and understand it, it says that it could have been collected wrong, maybe not, transferred to lab, specimen at the bottom, rectal exam specimen. This is the one they took the DNA results that came from the HSV test. The second one is Exhibit 2, dated 10/29/2013, office visit, HSV, history, outbreak, lab reports, did the same test results was negative. So that's dated on 10/27. That's the DNA.
Yeah, I believe, sorry, I don't want to cut you off, sir.
No,
I believe
go ahead.
we have everything.
You two can talk to each other without going through me.
Thank you. I believe Mr. Smith did send us everything. I just didn't want to waste either Mr. Smith's time or your time going through everything, but he sent us a complete packet. I'm sure he sent this before, like he says. It's just the state's position is, I just want to make sure that this is what we're relying on when we're answering our motion. This is, or filing our motion for summary judgment. Are these the only documents that I'm using? Or the defendant, the petitioner's relying on?
Well, no, it's not totally, but these are the ones for the sake of the hearing right here.
Mm-hmm.
That's where the state finds issue, Your Honor.
Okay. Well, go ahead, Mr. Smith.
These are the DNA documents.
Yeah.
The other ones is medical reports with test results of a different variety. They may be used, they may not be used. But these definitely going to be used because these challenge the assessment, these medical documents that they have right now, challenge the assessment of Dr. Nina Livingston of DC testing positive, her test results about wound culture, her testimony about how they occurred, where she got it from, how she came to her analysis. This is what that's relying on. The other documents that I have, per se, they won't be of evidentiary value unless something else came up that was different outside the scope of this.
Mm-hmm.
So,
so, Mr. Smith, can you identify in particular what documents you have sent the respondent that show newly discovered DNA evidence?
Exhibit 1, 2, Exhibit 4, Exhibit 11.
Sorry, can we just slow down a little? I'm writing when you're talking. So, no, it's okay. So number 1, 2, 4.
1, 2, 4, 11, 13, the affidavit of chain of custody.
Is there a number for that one?
I believe, but I don't have it on this paper. It might be 14.
If I could just have a moment to check, sir, I can see.
Go ahead.
And I have another one that the state has, but I'm not sure. I didn't mark that one because I was saving that one because the state has it, but I didn't I didn't resend that in that package. But I have another one that the state has, but I'm not sure. I didn't mark that one because I was saving that one because the state has it, but I didn't resend that in that package. But
So all I have is 1, 2, 4, 11, 13. I'm not seeing. What was the thing you were talking about, sir? The one after 13?
the affidavit for chain of custody by April Slade,
I don't see that.
that's been submitted. That was one of the ones he mentioned last time. That's in your custody. That I sent probably like 5 times. Because every time I send the evidence, I send that affidavit with it attached, stating how I
Your
got
Honor,
it.
and then, so 1, 2, 4, 11, 13, some affidavit of an April Slade, which I'll have to see if we have, but it's not, my understanding was this packet was supposed to contain everything that was going to be argued, Your Honor, and so I can look, it's just not in this packet. And then I also just want to, go ahead.
Do you have April Slade affidavit?
I said no, it's not in this packet. So, Your Honor, there's also a final determination regarding a Russell Winiger. It's not numbered, but it says final determination. It's supposed to be a 7-page document. And we only have pages, the only pages that were submitted in this packet were 1 through 4 and then page 7. So we are missing pages 5 and 6. Just so the court, it's a document dated March 31st, 2014. It is a final determination regarding Russell Winiger. So we're missing 2 pages of that.
And Exhibit 8, do you have Exhibit 8?
I can check. Give me one moment, please. It is a follow-up child abuse consult that's redacted. Is that what you're referring to?
Yes.
It's a 1-page document? Okay.
Yes.
I have that.
Okay. Just making sure.
Thank you.
So the ones you don't have is Russell Winiger, page 8 and 9, I believe, 7, something.
No, 5 and 6 of 7. There's 7 total. We don't have 5 and 6.
All right. You don't have Ms. Slade's affidavit?
It's not in this packet. No.
Okay. That's noted.
Okay.
And so I assume I would have to send that in. And while I'm at it, I might as well send the rest of these documents, but I only sent them in because they pertain to the DNA, the 1 and 2, and 11, and for purposes of, and 13. You have 13?
Yes.
All right.
Let me ask this. I do have some of your requests for admission, Mr. Smith, because it was attached to respondents' response to request for admission. And so, for example, your first request for admission is Connecticut Children Medical Center. Do you admit that copies of medical documents received by Mr. Mariani are true and accurate? And your response, Ms. Davis, is denied. I'm wondering if there's something that we can clear up to so that you could admit that the documents are true and accurate, or what really is the reason you're denying that?
Sure. If you could just let me pull it up, because
Yes.
Attorney Mariani did this, so I'm kind of at a loss.
Yeah.
Is the court referring to, I have the judicial e-services pulled up. Is it 184?
No, 181 is the state's response to plaintiff's request for admission. And
Perfect. And that's where Attorney Mariani hand wrote in it?
So an attachment to that is a copy of plaintiff's request for admission. It's basically maybe the fourth page in that document is a copy of the plaintiff's request for admission. That's all I have from the plaintiff's request for admissions. But I see on page 1 of plaintiff's request for admission, item number 1, CCMC is denied. And I'm wondering what the uncertainty is there that maybe we could clear up.
Yeah, I'm looking, Your Honor, I see exactly what you're looking at. I see Attorney Mariani wrote C states filing of September 9th. So I just want to see what that is.
Yeah, let's look at that.
If the court has a line number for that, is that 184 or 185?
Let me go to the pleadings.
Thank you. I apologize.
No, that's all right. Go ahead.
Now I might be able to clear her up.
Yeah.
Mr. Mariani sent a response in to my amendment. The second amendment. And I think he might be relying on the fact that he stated that he was denying the documents, number 1, because he didn't know what I was talking about. And 2, that the state should disregard and throw out said documents because I obtained documents illegally. So that's what might be the holdup. So that party did claim that the documents was received illegally. So they may not want to admit to them because they assuming that I'm not even supposed to have them.
So
that was his point.
Ms. Davis, I'm looking at 184. That's the state's objection to the petitioner's request to amend. So I don't think that's that relates to the request for admissions. 185, let's look at that. No, that's the state's position on summary judgment. I think the response to the request for admissions is 187. Matter of fact, no, that's request objection to subpoena.
That one I actually wrote. So
yes, you did. Right.
I understand that one.
Yeah. Okay. All right. How about 181 is what I read from. So I think those are the only responses to the request to admit.
I'm looking at bear with me, 183.
Okay. Oh, answer in special defense. No, that's what it sounds like. An answer in special defense to one of the petitions. So I don't really see anything in addition to 181 responding to the request for admission, but
I have it in front of me. It's dated August 19th, 2025.
Yeah.
The state response to plaintiff's request for admissions dated August 19th, 2025.
Right. I have some of that. And I'm not requiring the state to admit.
Correct. Me neither. I mean,
to things. Yeah. Okay.
Because it seems like the state doesn't want to admit it. So I'm really past that because I can call the witnesses in and authenticate it through Dr. Fonda Gravino and Dr. Nina Livingston and probably even the records keeper. I mean, so.
Yeah.
I understand the court's position. If the court wants, just because I don't want to speak for Attorney Mariani, I could see what he says about this and then I guess file something just so Mr. Smith can see what I'm saying, you know? I don't want to just email the court because I can't email Mr. Smith. So I could just file a notice or something.
All right. Well, here's what I'll ask is take a second look at the plaintiff's request for admission. All he's asking is that you admit that these are true and accurate copies. although there's some language there that
Well,
that
this is referring to two doctors, Nina Livingston documents and Fonda Gravino. The other documents.
I could look at it, Your Honor.
Okay, and so for example, you might be able to say as to one, that the state admits that these are true and accurate copies of the CCMC medical records. You might not admit to the way Mr. Smith characterizes it in the last line of paragraph 1, but you might.
I see what the court's saying.
Okay, good. So just take a second look at that.
Okay, and I'll talk to Attorney Mariani hopefully this week or early next week, and I'll get that filed as soon as possible.
Okay, let me ask you this, Ms. Davis, if I grant the petitioner's request to amend to allow him to file the third amended petition, you're entitled to respond, including by motion for summary judgment. When could you have that motion for summary judgment?
Do you mind if I just run to attorney, like one office down? I just want to look at Attorney Mariani's calendar.
Okay, I do not mind.
Thank you. I'll be right back.
Right.
Your Honor.
Yes, Mr. Smith.
I got a few housekeeping things. It appears that every time I send the court documents, they never get, like, per se, the medical documents. You never have them. I mean, I probably sent them like 3 times, Your Honor. I sent the package before, certified mail, for the signature signed by the clerk upon receipt. That never got there. Then the package I sent with the amendment, you say you don't have in front of you. Correct?
Let's see. You mean the package you sent with the request to admit?
Right, but I sent the documents before that never got logged. Medical documents. It's like I just keep sending them and sending them in and sending them in.
Just my concern, Your Honor, and I know Mr. Smith, there's been multiple prosecutors on this matter. There's been a lot of people, a lot of issues, but our understanding was we were just going to get one document, one filing from Mr. Smith that has everything that he's going to use. And that's what I'm concerned about.
Yeah.
So
go ahead.
I can resend that. I can send things I'm going to use, things I might use, things I think that because it's a stack of medical documents. So if the states want to see all of them, some of them are pertinent, some of them not. It might be 50 pages, I'm not sure, but I can send all of them.
All right. You do not have to send that to me, Mr. Smith. It's normally on a request to admit, you just file something like a notice that you have filed a request to admit without all the attached documents.
Correct. Okay. I have done it. I sent the notice separately, but I just the medical documents for court's use, because last time we had the hearing, I remember you didn't have anything, but they had it, and it was that was summary judgment, I believe. You didn't have the medical documents.
But yeah, if you and I acknowledge that, and I've heard this from other prisoners, that sometimes we don't get things that you have sent. But right now, I don't feel I need anything that that you've tried to send. I have the pleadings, and that's really all I need at this point. I assume, Ms. Davis, that coming back to summary judgment, that you will attach any records that you might argue don't meet the exceptions to this, that Mr. Smith might be relying on, that don't meet the criteria for an exception to the statute of limitations?
Sure. Yes.
Okay. All right. So I'll see him then.
Okay. Just
actually,
back to sorry.
Yeah. Back to summary.
I was going to say back Yes, so Attorney Mariani is actually starting State versus Milner in Hartford. It's a homicide case on October 3rd.
Very familiar with that.
Okay.
As you
He's
may know.
starting it October 13th, I believe.
Oh,
That's when jury selection starts and evidence starts the 27th. So I don't know if the court wants to go after that. Attorney Mariani's the writer of this duo, so.
yeah. Well, October 13th is not far away. It would be a lot to add, especially since he's sick. And it's
Yeah,
October
he's pretty
1st.
sick.
Yeah, I can't really ask you to file it before October 13th.
Thank you.
Yeah. It's just gonna delay things, but I mean, the petitioner has filed this new petition, and that in itself delays things. So, can let's see, the trial starts on October 27th.
Yes, Your Honor.
Right.
No,
So
the trial starts on November, Your Honor. I mean,
This is
Yeah.
a different trial, sir. Different trial, sir.
yeah,
Right.
so we're not going to be able to meet that December trial dates, because with the new petition, the respondent is entitled to file a new response, which will be a summary judgment motion, and that's just going to set everything back. Okay. So I am familiar with the case, the Milner case. That'll take, and he is pro se, so that will take a couple weeks to try.
Yes.
So realistically, I'll suggest something like the end of November.
That's fine with the state. He doesn't look,
Okay.
his calendar looks clear after Milner.
Okay, so looking at the calendar, let's see. November 27th is Thanksgiving, 28th is the last working day in November. So can I say November 28th?
Sure.
Okay.
And I'll have counsel. That should work. That'll work. Thank you.
Okay. All right. And again, it would just be helpful if the state would attach as exhibits any documents that we're going to rely on, just because
Sure.
It's difficult for Mr. Smith sometimes to get a lot of documents to the court. Okay.
The state can do it.
Okay, good. And Mr. Smith, how long would it take you to respond to the state's motion for summary judgment? I'll give you whatever time you need.
I'm not sure. It depends on how long it is.
Okay.
Do
Do you want to wait until it's filed, and then we can set a scheduling order?
Yeah.
Okay. All right. So let's do that. We'll have another conference. And then maybe then we can set all the remaining dates to be set.
Okay.
So let's see. Gonna give the mail a little time to get to deliver this summary judgment motion to Mr. Smith.
Okay.
And so I'll suggest December 8th at 10 a.m. for scheduling conference.
I'm sorry. May we go to like the 11th or the 12th? I'm out of the country the 8th.
Yeah, except actually, so the 12th is open because I had it scheduled as a trial of this case, but that's
Okay.
not gonna happen. Scheduling conference at 10 a.m.
Sure. Thank you.
Okay. All right. Final matter on the agenda is Mr. Smith, I have, I think, all of your applications for subpoenas, and I know the state has objected to a subpoena for the victim, and I'm not going to act on any of these because the trial is not going to take place on December 12th. And so I don't want subpoenas to go out for a trial that's not going to take place at that time. I'll just add that with regard to the victim, my general approach on something like this would be to reserve decision on it until I've heard the rest of the evidence and see whether I think it's necessary to call the victim. I might say it is, I might say it's not, but I don't want to subpoena the victim until I determine that his testimony is necessary. So that's what you can kind of anticipate. You can, for the next scheduled trial, you can file all your applications and the state might file the same objection, and that's what I'll probably do. Okay?
Okay.
All right. So, again, I'm not going to act on your applications for subpoenas. Do you have copies of them with you, Mr. Smith?
No.
Oh, okay, because
I was waiting for the return of them.
I see. So, maybe just to save work on your part, I'll talk to the clerk, but maybe we can hold on to them. And if it comes to it, we can just change the date so that you don't have to redo them.
Correct. Is that like I think it's about 12 or 13, right? Something like that.
Here's what I have.
Because I sent 2 packages. That's
okay. Why. All right. I have, let's see, trying to see. Oh, this is application for waiver, subpoena for DC, the victim. Then, next is Michael Peck, trial counsel. Then next is State's Attorney Deborah Collins. By the way, she has left the State's Attorney's office. I don't know where she is. Kelly, Ms. Davis, do you know where she is?
I believe she's living in Florida.
That's what
is
I
the
heard.
last I heard.
Yeah, so that might be she might be difficult to get. Dr. Gravino, Fonda Gravino. Let's see.
Livingston.
Okay, Officer Winiger, Dr. Livingston, and
medical records.
Let's see, medical custodian of records, CCMC, Dr. Udo, St. Francis Hospital. So, I mean, I'm going through them, but it looks like I have all of them. Dr. Guerrera, Asylum Hill Family Medicine.
Correct.
Custodian of Records, Asylum Hill Family Medicine. I might have missed one, but I think I have most of them. So I'm going to hold on to them. I'm going to hold on to them for now. We'll see if you need them, and we'll try to find the easiest way of getting them out next time. Okay?
All right. So you would save them and possibly change the date?
Yeah. Yeah.
Okay.
I'll talk to the clerk about that.
Thank you.
So just to summarize, I'm going to put in an order here. And it's going to grant the request to amend the complaint based on the petitioner's statement that he is alleging fraudulent concealment and newly discovered or available DNA evidence as exceptions to the statute of limitations, but not other newly discovered forensic science evidence. Am I correct in that regard, Mr. Smith?
Well, it's this the thing.
Yeah.
Last hearing, summary judgment, you informed me that forensic evidence claim, because I think I was construing them together because my DNA evidence is forensic evidence.
True.
So when I was quoting it, I was quoting B1, and B1 is new technique. So you were saying that's not correct anymore because this new case law Myers claims that, and I think I did read Myers, and I went back and read Myers, and it kind of says that it has to be a new technique. I would probably disagree with that because I think they was talking about new evidence. It couldn't be new evidence of any kind. My evidence is newly discovered forensic / DNA evidence.
Okay.
That's what it basically is. It encompasses the whole statute. 52-582A, 52-582B. You informed me B1 was for just a new technique. I was referring to B1 in the sense that because my evidence is DNA with forensic analysis that's totally different from other forensic analysis that was used at my trial.
Okay, so you
am I making sense? Am I making sense?
Yes, I follow what you're saying. You're saying your newly discovered forensic science evidence is DNA evidence.
Correct.
Okay.
Correct. And it was several different analyses done on the DNA with different outcomes.
Mm-hmm. And you have identified for us the exhibits that you're relying on to
and I
show.
have a few more that I'm going to send to the state since they want all. So I'm going to send everything.
All right. Well, I just so that we're framing the issues here, because this has been one of the difficulties in this case, is that the issues keep shifting. I want to try to identify the documents you are relying upon to show that there's newly discovered DNA evidence, and you have listed these exhibits.
Correct.
1, 2, yeah. Are there any other exhibits that? Yeah.
Yes.
Just the 2 documents that are missing that we talked about?
Oh, it's 2 more, well, several more, but them the ones I was relying on for the hearing because it was so many. I used the ones that was available that the state was familiar with that I used from the beginning.
Well,
them was the ones I used. Them was the same documents I used from day 1 till now.
Yeah. Well, I'm trying to frame the issues because we've had difficulty with this, and identify the documents that you claim show newly discovered, we'll call it forensic science DNA evidence. And you have identified 5 or 6 exhibits. Are you saying now that there are additional exhibits that show newly discovered DNA evidence?
Correct.
What are they?
There are blood test results, wound culture results, transmitted disease test results from different types, positive, negative. At trial, they stated there was only 1, but these documents show that the victim tested positive for staph infection, tested positive for hepatitis, I think B, but they stated it was only HSV tested for. I have medical documents that state that the victim tested negative for HSV, that wound culture Go ahead.
I'm trying to identify what exhibits you're relying on to show newly discovered forensic science / DNA evidence, so that the state, so let me just finish, so that the state can make its argument that this is not newly discovered. So would you please state the numbers of the exhibits so that the state can file a motion for summary judgment?
Well, I stated the ones just a little while ago. I believe I said 1, 2.
Right.
Let me get it out again.
Right. I have it. It's 1, 2, 4, 11, 13, 8.
Right.
Correct?
Correct. And I have some additional.
Okay.
So my concern is the additional, Your Honor.
Yep, mine too.
And I will have them out in the mail because you gave them a date of December to respond.
Yeah.
Right? Correct. So I will have them out within a week, 2 weeks. So they will have.
Is the response day is November 28th, right? The last working day of November, right?
Yeah, but if the state doesn't have, if Mr. Smith has not supplied all the documents he's relying on for an exception to the statute of limitations, I'm going to give the state additional time until it has all the documents. I thought we went through this and identified the documents, but if there are more, then I don't think the state can start on the motion until it sees what the petitioner is relying on.
Correct.
Okay, the state agrees.
Okay, so when can you supply the additional documents you're relying on for an exception to the statute of limitations, Mr. Smith?
I can have them out in the mail by next week.
Okay.
No later than 2 weeks.
Okay, so I'll give you 2 weeks. And here's what I'll do. I will extend the state's deadline to December 5th.
Okay.
And we'll still have our conference on December 12th.
Okay.
So, Mr. Smith, just wondering what you could entitle this additional package that you're going to send the state. I mean, to me, it sounds like it's additional documents relied upon to or that show newly discovered DNA evidence.
Correct.
Okay, so could you put a cover sheet to that effect?
Okay.
All right. Okay. So I will enter an order granting the petition to amend the request to amend the petition based on the representation that the petitioner is relying on fraudulent concealment, and we'll call it newly discovered forensic science / DNA evidence within the meaning of the statute.
Can I?
And yeah.
You putting the cart before the horse, it seems like. You're quoting line, what is that, 12 or 7, whatever, as the standard that I'm relying on. I'm relying on 1 and 4. Number 1 and 4. 52-582A. I'm relying on that with additional fraudulent concealment that you're quoting. You're quoting fraudulent concealment as the baseline, and I'm relying on the fact that I have newly discovered DNA evidence of a forensic nature.
Yeah, I understand that. We spent 5 minutes on the question of are you also alleging fraudulent concealment as an exception to the statute of limitations? And after 5 minutes, you said yes.
Correct. I said yes, but you starting off with is fraudulent concealment, then put it in. That's not sitting right with me.
Okay, I'll reverse the order.
Right, because my basis of my petition states 52-582A 270 4255 paragraph 4 DNA evidence undiscoverable or available. Then as it get in, it goes to fraudulent concealment.
Okay.
So the baseline is DNA evidence.
Okay. All right. I'll reverse the order of those. And give the state to December 5th to answer or respond to the petition. We'll have a scheduling conference on December 12th. I'll give Mr. Smith 2 weeks to supply additional documents he's relying upon to show newly discovered DNA evidence. And I'll take no action on the applications for subpoenas at this time, but I will hold on to them.
Thank you.
Okay, so I think that summarizes what we've talked about and what I'll put into an order.
Okay.
Mr. Smith, is there anything else?
The screen froze for a second.
Yes. Oh, I'm sorry. So what's the last thing you heard from me?
You was I'm not sure.
Okay,
I don't know. He froze again.
Really?
Yeah, he's frozen, I think.
Oh, jeez. Well, Mr. Smith, can you hear me now?
Yes, you
Okay.
were saying that you was going to hold a request for witnesses. That's the last thing I heard.
Yeah. Okay. That's basically all I said. At the risk of tempting fate here, I'm going to conclude the hearing and say I will enter a scheduling order today or by Friday that summarizes what we talked about today. Okay?
Thank you.
All right.
Thank you.
Thank you, Mr. Smith. Thank you, Ms. Davis. Have a good day, both of you, and we will stand in recess.
Thank you. Bye, everyone.
Court stands in recess. Thank you, everyone.
Thank you. Have a good day.
I love you guys so much. Be safe, be well, sleep sweet, and much love.